This is WAAY 31 Law Call.
Hi, welcome to WAAY 31 Law Call. I'm Robert Lane. Sharon Doviet has the evening off. Well, if you've ever had a legal question, this is your show. It's Ask Us Anything. So think of robbing a bank, think of hurting a traffic accident,
right?
Trouble with your neighbor, this is the show. Will League is here from Timberlake and Lake, and the
That's right. You know, hey, tonight's an interesting topic, Robert. And for those watching, we got a special treat. We got a local legend, Robert Lane, with us tonight. Thank you for coming up.
Now, let me tell you, if you want someone who cares about your case, this is the lawyer for you.
Goodness.
And he's like a bulldog. He's like a bulldog.
So we're talking a little bit about whatever they want to talk about: criminal law, 18-wheeler wrecks, medical malpractice, domestic relations. So all that kind of stuff,
That's
Robert.
Right. And call this number. 256-536-0077. Get your call in now. You'll be the first on the docket.
Right.
Well, we have a little video we want to show you. This is from YouTube. This is You Make the Law Call. Will, keep your eye on that blue card there. That's your client. And
Right.
What are you advising? What's he doing?
Here's the thing: the blue car has a duty to yield the right of way. Now, there's an argument that someone waved him or her through, but you cannot delegate that duty to anyone else. So, if you fail to yield the right of way, you're liable. Your insurance carrier, all those things. So, you want to go and document the scene, make sure everyone is, you're looking after injuries, all that. Property damage is way later, Robert. But blue car failed to yield right of way unless we can put speed on that particular vehicle, and you can't delegate that duty.
Wow, amazing. Well, now you brought an attorney to help us out here who specializes in criminal law.
That's right. We got Matthew Bailey here, and Matthew, thank you so much for coming up, staying up late with us. We got, so we were talking a little bit before the show. You do a lot of criminal work,
absolutely,
and appeal work. So someone gets arrested, they're being held. What is a rule? What are some of the initial filings if a prisoner or if someone being held usually file that you see?
Yeah. So because I take appointed work here in Huntsville as well as retained work.
And what are the difference between those two?
Yeah, so appointed work is essentially work that the state of Alabama has said this person is indigent and they can't afford an attorney. So I get appointed by the court, and a person who retains me is a person that says I don't want an appointed attorney, or they make too much money. So those people are people that kind of come in, hire you under a contract.
Interesting. So I come in usually on the civil side. So for example, let's say there's an 18-wheeler wreck and the driver was DUI. So oftentimes we'll start, gathering evidence, things like that, but the district attorney in charge of, who's for the people, will charge that particular driver with a crime DUI. So oftentimes we do not get involved until your criminal, let's say you're assigned to defend the driver. You will not let him testify in my case typically without his criminal case being over. Why is that?
So typically you do not want a defendant to testify in a civil case until the criminal case is resolved. The reason being that you have a Fifth Amendment right to not have to testify and give incriminating information regardless of whether it's a civil or a criminal case. And that right follows you all the way through to the initial appeal. And if you have, and this can sometimes really delay civil cases, and I've certainly gotten my fair share of earfuls from civil attorneys for that sometimes.
Right.
But you have to protect the defendant's rights, and if they didn't testify in trial, then those rights still exist even if they get convicted until that appeal is completed.
Interesting.
Okay, guys, you ready for your first phone call?
Absolutely.
Now,
Absolutely.
You can call us too. The number is 256-536-0077. But TM from Morgan County has been kind enough to give us a call. What's on your mind, TM?
Hey, good afternoon, or
Hello.
evening, I should say. I really appreciate you guys taking my call.
All right, get into TM.
What
Thanks
I
for
have
calling.
going on is that I had a tooth removed, extracted, and I was supposed to have an implant put in. And the person that put the implant in put it too far back in my mouth, and the cosmetic people that were putting the tooth in or going to cap it said they couldn't work with it so I have to have another implant put in. Well, I wrote a letter. Well, first of all, I went back to the guy, and he was going to charge me a second time for the second implant. And then I wrote him a letter and told him that I felt this was unfair, and I've been going to Birmingham, and they're doing a pretty good job trying to repair the mess I got into. But
Right.
It's taken me nearly 2 years. They had to do some major work to undo what he had done to me. And I need some consultation about time limits. Now, like I said, I've already written him a letter, and he refused. He said he wouldn't pay anything.
Is this in Alabama?
It's in Alabama, not
Right.
far from Morgan County.
All right, so first thing to talk about is time limit. Usually you have 2 years from the date of any injury or malpractice. You're looking at a medical malpractice claim against the dentist. And there's a 2-year statute of limitations period, meaning your case has to be filed with the appropriate court within that time frame, or your claim is lost. You will not be able to bring that claim. The next question is was there a breach of the particular standard of care? So you have an implant. You go in, you sign all those forms. Some of those are consent forms that you consent to the dentist doing work on you. You consent that some of these issues with this particular procedure are common complications. You see those forms where it's blood clots, infections, all those things. Sometimes it's a common complication of that particular procedure. Sometimes it just didn't go as well as the doctor thought it was going to. Is that malpractice? Well, you have to have another similarly situated physician to come in and testify that yes, there actually was a breach of that standard of care, and that breach was the proximate cause of the damage to your teeth. So if there's a breach of standard of care, there may be an action for that. Now that's all the legal side. In reality, you have to look at what would it cost to maintain an action against this particular dentist, and what are your damages. You don't want to throw good money after bad. Those cases are expensive, to file and try. You'd have to have an expert to come in. And then what kind of expense would you go to fund and prosecute that case, and what are the likelihood of recovery, and what's the likelihood of the recovery being enough to warrant the time and attention to a medical malpractice case. You did the right thing by going and talking to your dentist. That's all. We always encourage people to go and see if you can work it out. Absent that, you're right. Sit down with an attorney, and you'll have to have a similarly situated physician review those records to see if there was in fact a breach of standard of care. And Robert, Matthew, a lot of times we'll get medical malpractice cases in, we get the medical records, we hire experts to look at those type cases to see whether or not it's something to go forward with. And TM, he paid for the service. It wasn't the service that he had paid for, and now he's even in more trouble with getting additional treatment down in Birmingham, and it gets costly. So yes, you're correct. Go and sit down with someone who handles medical malpractice cases and see if that indeed was a breach of standard of care.
Talk to me a little about DUI cases. So they affect both of you.
Yeah.
On the criminal side, and then if I have an accident.
That's right.
Yeah, so with DUI cases, there's a certain amount that that I'm trying to see whether people have followed the proper procedures, whether or not there's been blood drawn, all of these things that really affect the strength or weakness of the case that may or may not be something that comes up in the civil case, as well as the fact that DUI cases also have an administrative part about your license being suspended for a certain amount that you can try and challenge, but that's obviously beyond the scope of a lot of civil attorneys' knowledge. And so looking at those, because it's such a common thing in Huntsville, you really have to have knowledge of how to work both the administrative and the criminal, and then also be able to, on my side, at least protect the client's rights.
And when you're protecting the client's rights, that's an important concept. Now, we often are like the district attorney. After the criminal case is over, we're prosecuting the civil case. If those out there, they can remember the O.J. Simpson. Criminal case went first, and then the civil case went after that. And so we will go on some of the same evidence, and we'll actually call up or subpoena someone from the Alabama Department of Forensic Sciences to verify the blood was taken properly, to verify the chain of custody, to verify what the outcome of that particular blood content shows. Is it alcohol, a banned substance, controlled substance, how much was in his and her system, similar to what you would do in the criminal case. And so, Matthew, when you're protecting rights, you need to make sure that all those I's and T's are crossed when we're trying to get that evidence in against your client. Tell us a little bit about that.
Yeah, so there are some very interesting parts to even a basic DUI case, which is that officers have certain duties and certain things that they have to follow to be able to present a good DUI case. Part of that is, well, was the testing that they did on the roadside good? Were they following the procedures? From my point of view, those are things that I look at and go, all right, well, they didn't go with the manual here. They have a certain amount of training that they have to look at.
Right.
And I have the ability to try and challenge that. And obviously, like, we come at it from different ways versus with the officers, because I'm looking to see if there's something that I can find that discredits the officer versus, especially if you've got a DUI case and you've got injured parties, you're trying to hold that up as a firm,
Right.
firm
And
injury.
if they can't get that into evidence, that helps your case. Your client might not be guilty, correct? And
Correct.
That's your job.
Correct.
Mm-hmm.
But even if they are found not guilty, that doesn't mean that they couldn't be liable in a civil trial.
That's right. And oftentimes, the elements don't match up for a criminal case, which is beyond a reasonable doubt. But in the civil side, the standard of proof is to your reasonable satisfaction. So beyond a reasonable doubt's up here. Beyond your reasonable satisfaction, or just to your reasonable satisfaction, is a lesser standard in the civil side.
Absolutely.
Mm-hmm.
Well, both of you have jury trials, so I'm sort of interested in how you pick that jury. And do I really have to serve? But we'll find out. If you have a question, 256-536-0077. We'll be right back.
WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviat. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
We are taking your calls on any subject matter tonight. So, give us a call right here. Matthew Bailey is with us. And Will League of Timberlake and League. And Will, you had a shout out you wanted to do.
We did. Timberlake and League, we were able to be a proud sponsor of Shakaran, which is a ray of hope, and basically provides vital social services to anyone in need. And so they're really trying to go against sexual trafficking, discrimination, any type of domestic violence. And basically there are hope lines set up for anyone in North Alabama. You can call these lines, whether you're, you or a loved one. And it was through, this was a cultural dance, a celebration, women's rights, women's power, and basically, to get out the word that there is hope, there is a hotline out there you can call, and you can get, any type of, you can get counseling. They can provide services and put you in contact with social services that can help you in your situation. So no, there is hope out there, and there is, a hotline that's, people are really doing good things with this organization. We're proud to stand with them.
Well, excellent. We can always count on Timberlake and League. Thank you so much. Well, we have Howie from Huntsville, who's been standing by. Thank you, Howie. What's on your mind tonight?
Yeah, I represented myself in the Madison County Circuit civil case, and I lost. There's a judgment against me. I filed a motion to either have the judgment amended or a new trial, and in the caption I typed in oral argument requested. And the very next day, the judge dismissed it without having the oral argument. Can I appeal that? And if I do and I get that reversed, what happens next?
What kind of case was it?
It was a circuit civil case. It was a case for a monetary award.
Okay, were you the plaintiff or the defendant?
No, I was a defendant.
Okay.
And I lost, and I filed an I filed an ARCP 59 motion, and in it, on the caption, right in the heading on the top, I typed in oral argument requested.
Right.
And they dismissed it. My request was denied the very next day without any oral argument. Can I appeal that? And if so, what happens?
You can appeal. Now, you know, in the criminal world as well, you do a lot of appeals. So just because you request oral argument, the judge does not have to grant that request, correct?
Absolutely. I mean, it's one of the things that if this goes on appeal, you will absolutely be able to argue that you should have had the judge hear your motion. But there are some timelines that you really need to be looking at right now in terms of filing for the appeal. You get 6 weeks usually in circuit cases to appeal to, in this case, I'm guessing either it's going to be the Alabama Court of Civil Appeals or the Alabama Supreme Court, depending upon how much money was up for in the case. And so I think that that's really what you need to contact an attorney that does appeals and look at what your next steps are going to be. But you absolutely can have the court come back and make the court have that hearing.
You know, and Howie, you're raising one. It sounds like you're well versed in the rules. You've been looking at the right stuff. Just proceed with caution. You know, it's difficult trying a case if you saw you tried it yourself. But even more so when you get into appealing and you get into the appeals process, you can really, you know, find yourself, you know, in trouble with the procedures, all the things that the appellate court is going to require. So I'd encourage you to sit down with an appellate lawyer who you can go over your case with and make sure there's no time limit that's missed, because once it's missed, it's gone. So make sure to sit down with someone and go over your case.
Well, we're going to go to Scottsboro now. And Scott, you have a question for the panel.
Good evening, Scott.
Nope, Scott hung up on us. Listen, talk to me about juries. And do I have to be on a jury? Sounds like it's a
couple things. You know, it's a cornerstone of our legal system. We want to ask our community members what they think about this particular case. You know, we get a jury duty. I'll ask jurors, you know, when we sit down for a process called voir dire, and we're actually asking them questions really designed to see if they can be fair to both sides. A lot of people these days, especially since the pandemic, Robert, are frustrated about having to come to jury duty. That's part of your civic duty. A lot of people attempt to get out of jury duty, and I get a lot of calls on that Monday morning. Do I have to go? You know, and the judge can censure you if you don't show up. And if there's not enough jurors, they'll send the sheriff out to pick you up. So yes, you do have to serve. Now there's exceptions. If you've got a reasonable issue that you have to attend to, the judges are really good in trying to let you do those things. But they do also a good job to try and determine what's realistic and what's not to keep you on the jury. So in our cases, you know, oftentimes we want a jury to hear the case. Sometimes they're so complex that it's better for a judge. Now, in the criminal side, what's your experience, Matthew?
I think it really kind of depends. I want people to want to serve on the juries that I have. And there are significant advantages to kind of having some people who may have a little bit less orthodox views being on your jury. So it is pretty easy to get out of jury duty if you get there and you just say kind of ridiculous things. I don't want to be here. I got a doctor's appointment, blah, blah, blah. But it's very important to our system. And if we had people that didn't take the jury system seriously, we'd really be kind of rubber stamping cases that should be considered very thoroughly.
Yeah, I would imagine both of you have got stories. But here, can I get in Mark from Florence?
Absolutely.
Here, Mark, you're on the air. Mark, you with us? I guess he isn't, so go ahead.
Well, so there are some cases that don't have juries. So if you're looking at domestic cases, divorces, child custody, things like that, those are judge cases. And when you talk to the judges, those are some of the most difficult cases they decide when you're talking about, where a child is going to spend most of their time, things like that. Workers' compensation, you'll just have a judge. But other cases, you have a right to a jury trial, and the lawyers determine whether or not they want to file that in their initial pleading. The defense can request a jury as well. And so it's a vital cornerstone of our legal system, that makes us unique in letting your neighbors determine what's reasonable and what's not in this community.
Okay, the number one question we always get is, does a dog get a free bite here in Alabama?
I would say that depends on what kind of dog, and maybe if there was some hints of whether that dog was having some problems before.
That's right. That's right. If it's we talk about dangerous propensities. So if you've got a pit bull, a chow, dogs that we know that have dangerous propensities, there may not be a first bite, get out of jail free card. If you have a dog that's again has dangerous propensities, and you're negligent in maintaining that animal, and he or she hurts someone, you can be liable for that. However, on the other side, Robert, let's say you got a sweet little dog, never knew anything was happening, bit someone. Are you liable? You didn't know. And so if you reasonably didn't have knowledge of the dog that would hurt someone, that first bite you might be all right, liability-wise. The second one, not so much.
Okay, but are they going to arrest my dog? That's what I want to know.
They can.
They can.
Oh,
absolutely.
really?
And they can force you to not have custody of the dog for a period of time, and then the judge may have to order the dog be released at the end to you.
One of the craziest cases I've had, Dobermans got out, and Rottweilers. Lady's getting ready for church. She looks out the window. Her 6-year-old son is, grabbed by a shoulder by one Rottweiler and the foot of the other, and she heroically comes out, gets her child. She's chewed up bad, gets back in the house, and the kid was, really, really hurt, but the mother saved this child's life. In that case, the dogs were put down. They were being trained to fight, and they kept getting out. And so they can be euthanized if they're a problem to the community, and the judge will have to order that. And unfortunately, that does happen. But again, Robert, Matthew, we're seeing folks that got these pit bulls and don't take care of them. It's not the dog's fault. It's who's training them and who's raising them.
And I mean, you certainly also have dogs that have shown that they're going to go and chase after bicyclists.
Yeah.
They're going to go and chase after people that are running by the house. And the owner should have an idea at that point that dog is a problem, and that dog is going to be it.
Good information. We'll be right back. Stay with us. If you didn't get your question answered tonight, you can reach Matthew Bailey at the law office of Matthew A. Bailey here in Huntsville. That's 256-469-1486 or at matthewabailey.com. And of course, Will League is of Timberlake and League here in Huntsville, 256-536-0770 at law-injury.com.
And we always have family law attorney Sharon Dovey at Huntsville, 539-7337. She handles divorce, child custody, domestic disputes, SharonFamilyLaw.com. Matthew, thank you for coming up.
Absolutely.
Thank you
It
so
was
much.
great to be here.
And you can watch Timberlake and League on Monday during the midday news here on Channel 31. Thanks for joining us. Sharon will be back next week.